Good evening, good afternoon, or good morning, as the case may be. It's my pleasure to welcome you all to this webinar on virtual hearings in construction disputes. My name is Matthew Christensen. I'm a senior foreign attorney in the International Arbitration and Litigation Practice Group of Kim and Chang in Seoul, Korea. And I'm also honored to serve as co-chair of the International Construction Projects Committee of the IPBA, which has organized this session. As we enter the second year of this pandemic, I'm very sure that we all feel we've attended well more than our share of webinars in recent months. But at the same time, this pandemic has prevented us from gathering as we normally would and from sharing insights, perspectives, and friendship with colleagues in the International Construction Projects Committee and with IPBA members more generally. And so in resistance to those forces of separation and isolation, the ICP committee has launched this series of informal coffee break style webinars of 45 minutes to an hour in duration. We began this series in early December with a webinar dealing with legislative responses in various jurisdictions to the impact of COVID on construction projects. Today's webinar on virtual hearings in construction disputes is the second in this series. And it's our intention to continue holding these events on a monthly or bi-monthly basis for the time being, as long as there's interest among our members. And in the process, we hope to create a forum for meaningful discussion on issues of interest to the members of the ICP committee, while also expanding opportunities for members to participate in that discourse. So with that background on the series in general, I will briefly introduce the program for today's session. We will begin with brief welcoming remarks from the president of the IPBA, Mr. Jack Lee, and we're very honored to have Jack with us. I'll ask Jack to speak in just a moment. We will then move to discussion of the topics set out in the slide that I think you should see on your screen. Yes, there you go. Guiding us through this discussion will be a panel of speakers. And I think it's safe to say that they don't actually need any introduction. They will all be very well known to you as long-standing members of the IPBA and of the ICP committee in particular. But I will say a few words. Our first speaker, Alfred Wu, is a dispute resolution partner in the Hong Kong office of Norton Rose Fulbright. Alfred is also a qualified civil engineer in Ontario and one of the most experienced construction lawyers in the region. And I'm pleased to say my co-chair in the ICP committee. Alfred will discuss institutional guidance and best practices for virtual hearings. Our second speaker is Marion Smith QC of 39 Essex Chambers in London. Marion will discuss the importance of procedural fairness in virtual hearings, and including some of the practical challenges that arise in the particular case of construction disputes. And last but not least, we have Dr. Colin Ong QC. As you may know, Colin divides his time between Brunei, where he is senior partner at Dr. Colin Ong Legal Services, Singapore, where he's counsel at Eldon Law LLP, and London, where he is affiliated with 36 Stone. And Colin will discuss techniques for and strategies for effective conduct of virtual hearings in construction disputes. So the basic format is that each of these speakers will speak for a few minutes, kind of kick off a discussion. And then we're hopeful that we will have comments from the audience and that we can pick up and discuss afterwards. And in that regard, I would like to alert everyone to the chat function that you're welcome to use, but also to request that if you have questions that you'd like the speakers to address and to discuss in particular, then please submit those through the Q&A function, not through the chat function. So that's a brief introduction to today's session. And I think without further ado, I'll ask Jack to give his welcoming remarks. Thank you.
Thank you, dear Mr. Chairman, dear distinguished colleagues and guests. I thank IPBA officers for organizing this timely seminar taking place under the devastating impact brought out by COVID-19 pandemic. I do appreciate the joint efforts and collaborations from all our members and officers working for IPBA during such a difficult time. The coronavirus pandemic has forced the legal profession to make huge adjustments as it deals with the global health and economic crisis brought on by COVID-19. When the COVID-19 pandemic hit the world, government restrictions on travel and movement forced sectors to diversify their operations. This presented a huge challenges for legal proceedings. Thanks to technological advancement, the industry was able to adopt virtual hearings as an effective alternative approach to physical hearings to avoid delays and ensure that disruption to legal proceedings were kept to a minimum. In the jurisdiction where I practice in, relying on the well-developed cyber technology, the legal industry has supported the use of virtual hearing for quite a long time. With electronic virtual communication systems and a long time with electronic virtual communication systems and immediate online transcript widely used by many, but nevertheless, the technology to facilitate a fully remote hearing has never been so urgently needed to be utilized than any other time in history amid COVID-19 pandemic. Probably in many other jurisdictions, the virtual hearing represents a new and somehow exciting phase for the legal industry. COVID-19 accelerated the number of parties choosing virtual hearings, but this is not the first time that proceedings have been convened with the use of technology. In early days, some courts or tribunals have been willing to convene hearings of urgent applications by telephone and have allowed witnesses to be heard remotely using video conferencing facilities, and some even provided their own rules or protocol on remote witnesses. Construction disputes are known to have many complex documents, from large spread hills to maps and drawings. Digital searchable documents are easier to navigate, organize, and position while screen sharing, ultimately reducing time often wasted when trying to locate a page on an exhibit. In many cases, even in a small construction dispute may involve more than 20 parties, including witnesses, experts, counsels, and tribunals, whose hearing and the tradition on-site way are hugely time-consuming. I suppose there will be a positive impact on the construction disputes landscape in this regard. Ladies and gentlemen, before closing my words, I would like to invite you to Shanghai Annual Meeting Conference on April 18 to April 21st this year. And I will surely bring an unforgettable event in Shanghai. Thank you for your attention.
Thank you, Jack. We really appreciate your being with us today and for sharing those comments. And perhaps before turning the time over to Alfred, I would just second what Jack has said about everybody participating in the IPBA. We obviously have a conference coming up in April, which I understand will proceed come what may. And we're looking forward to further information from Jack and from the host committee on that front. But just more generally, we really do hope that through this series of periodic webinars, we can get many people to participate in the ICP committee. And so that's obviously one of our key objectives here. But enough of that promotional discussion. Alfred, why don't you take the mic now, and you can start our conversation about the institutional guidance that we've received, and also best practices, guidance on best practices in the wake of the advent of COVID and the changes that it's wrought in the dispute resolution community. So,
thank you, Matthew, for the for your kind introduction, and also thank you, Jack, for his opening remark as well. Sort of just starting off on the first topic of our discussion, which is institutional guidance and best practice, for conducting, virtual hearing. As Matthew has mentioned before, the advent of COVID-19 has forced us to change our ways of operating hearings, in many ways, and most significantly in the ways in which people are less free to travel now than they were before. So we are forced into situations where there are going to be a lot more sort of hearings being conducted online through virtual means than they are being done physically. And these as a result of these situations, institutions, who are who are operating a lot of these hearings, or other institutions like even the IBA or the organizations like Hkiec, have come up, have tried to provide some response as to how people should be dealing with virtual hearings, and even before the before we had COVID-19, the IBA guides, which in their 2010 guidelines for taking evidence has already provided some stipulation as to what people are to do if they're going to give evidence virtually. So you will see those in Article 8 of the IBA rules on taking evidence, which is the 2010 rules, where it says that arbitral tribunal are allowed to use video conferencing or similar technology with respect to particular witnesses. And then in the commentary of the rules, it does indicate that in an application for permission to use these video conferencing facilities, the tribunal will have the discretion to decide, and the tribunal's decision should depend, among other things, on the sufficiency of the reasons given, the ability to propose protocol to maintain equality and fairness among the parties, and to do so in a way that is as approximate to live testimony as possible. So you will see that the focus there is maintaining equality and fairness, sort of equality of arms, if you like, when it comes to this sort of virtual arrangements, for giving evidence, but also they will equally apply to the hearing generally. So in terms of guidelines from institutions, the HKI, there are a number of institutions that have published guidelines, the HKIAC, CTAC, ICC, SIAC, and so on, and also the the Seoul Protocol, published by the Korean KCAB. But I'll come back to the KCAB in more detail later. But in all of these guidelines, perhaps I can start with the HKIAC guidelines, which is the shortest of all of them, and it provides some sort of very high level sort of guidance for people when they come to arranging virtual hearings. the amount of time that you need to give the the arbitration center, to organize things, and the mentioning in the Hkiec guidelines about IP-based video conferencing technology and cloud-based video conferencing technology, and so on. Now, one thing that I think, I don't think any particular guideline will be all-inclusive in terms of, the things that you need to consider. So I think, and none of these guidelines, represent, mandatory rules that you have to follow. So I would, if you are in a situation where you want to arrange virtual hearing for virtual hearing, I would invite you to look at the different guidelines of the different institutions, and there may be things in there, which will prompt you to think as to the things that you need to take into account when you're making that arrangement. One thing that is mentioned in many of the guidelines is to have a backup system, right? Whether you are, doing it, on a, on a cloud-based system or on an IP-based system, it's always, important to have a backup because, the internet does have, glitches from time to time, and it happens, often enough, sadly, it's being the sad reality, and also, by the time you're having a hearing, you are investing a lot of money, in engaging your counsel, in having your witnesses prepared, in having all the IT arranged, and so on. Transcribers, e-bundling, and so on. So it's important to have a backup system so that, if the main line goes down, you can still carry on. And that is very important. There's also the need to have a hearing manager, who can, look after, IT glitches as they come up. And you probably, if you have people in different time zones, you probably need to have a hearing manager, at each location so that they can look after issues as they crop up, try to line up, get witnesses prepared, get the IT prepared, and even getting, the coffee filled up and the lunch arranged. These are things that, you need to take into account. I say, we borrow from, different guidelines. If you take a look at the SIAC guidelines, it also, it talks about, you need to plan in terms of how long your hearing day is going to be. This is important because, when you're operating across different time zones, you in a way, you can have the hearing carry on 24 hours a day, but you probably don't want that to happen. So you need to agree among the different sides as to, what is the common window among the various, jurisdictions or time zones whereby you can have a good stretch of hearing. And my experience is that, when you operate between, fairly big differences in terms of time zones, that will cut into your hearing day. For instance, operating between Hong Kong and London, you probably, lucky to get 5 hours, and if you operate between Asia and North America, that it's even more tricky because the time difference is, could be 12 or 13 hours or even bigger, if depending on whether you are in the East Coast or West Coast. So and then, we talked about having a backup, but it's also important to sort of test your system. The SIAC guidelines talked about, testing it, twice, before before the actual hearing, and also at the beginning of each hearing day, you need to test your system. There is also the the ICC guidelines, talking about, different sort of measures people need to take into account, when they are, arranging virtual hearings. Again, there's the emphasis in the ICC guidelines about, parties being treated equally, full opportunity to present their case during virtual hearings. And then the ICC guidelines has set out a number of checklists for as protocol for virtual hearings, and also suggested clauses for people to include in procedural orders when they're organizing hearings. So each of these sort of guidelines do have things to borrow from when it comes to sort of thinking about organizing a virtual hearing. I mentioned earlier on about Hkiec. Hkiec has helpfully, published a series of reports, and they are still in the process of publishing these reports. So far, they have published, I believe, 4, one for Australia, one for Italy, one for US, and one for Vietnam. The Hong Kong one is still in draft form. I'm sure there are other ones that are also in draft form, which Hkiec is reviewing and will be rolled out in due course. The Hkiec guidelines will bring together the differences across different jurisdictions in terms of whether you can or cannot deal with virtual hearing, and one of the focuses of the Hkiec report is whether there is a guaranteed right to a physical hearing. If you have parties who if there is a sort of guaranteed right to a physical hearing, then it is a right of the parties, and it is not really for the tribunal to overrule that. And so the parties may be in a situation where they must have a physical hearing. But based on the report published so far, most jurisdictions do not have an express right to a physical hearing. And another situation is like what if you have a situation where one party wants a virtual hearing, but the other party does not want that. Then as a tribunal, what do you do? These are the questions that whether whether you are a tribunal member, or whether you are a party representative or a party, you will have to sort of consider and when it comes to thinking about virtual hearings. I want to quickly then move on to the SOL protocol, because the SOL protocol is I wanted to sort of focus on that because out of the various institutional guidelines that have been published, they seem to be the most most of the other guidelines talk about as a party, or as a as someone who's trying to organize virtual hearing, what do you need to do? What are the things that you want to think about? But the SOL protocol is published by the KCAB, is very prescriptive in terms of the kind of how you should organize witness examination, how you should organize your video conferencing venue, how you should present documents. It really goes into the very nuts and bolts, and and something as detailed as the minimum transmission speed to be used for your sort of for IT connection, and how you should make provisions for interpretations and recording, and it also talks about a backup plan. So it is worth taking a look at the SOL protocol. When you are sort of even though you may not necessarily be organizing your or including sort of South Korea in your hearing, but there are some very detailed sort of steps in there which be useful to take a look at when it comes to sort of organizing a virtual hearing. So that's what I wanted to say as my bit, Matthew. I'm happy to have my sort of co-panelists chip in on their experience about these guidelines and before they move on to their main pieces.
Thank you, Alfred. I think that's a very helpful kind of setting of the stage and helping us to understand sort of the framework within which we're operating and where guidance has been provided. And I would be very interested to hear from Colin and from Marion as to whether they have any experience using the Seoul protocol. Obviously, from my perch here in Seoul, we see it a lot, and some of my former colleagues were involved in preparing it. And I think it has, in my experience, it is a very sensible set of guidelines and quite useful. But I'm wondering, what is the experience in other jurisdictions? Have you seen it used in practice, or other similar, guidelines on best practices?
Well, shall I start with that? But can I just ask everyone who's on this call to humour me and get on the chat box, and would you just type in where you currently are? So I'd like to get a feel for whether we're talking to people, 60 or 70 people all in Singapore. Dubai, there we are, first one in London. That's the difference. Anyone else prepared to share where they currently are? That's quite a range. Singapore, Hong Kong, Germany. Yes, I thought it would be. That's North Wales. Boreda. It's lovely to see the range of people. That's the voice of the IPBA. And it's, I hope, also really one of the messages about what we're talking about. We're currently trying to solve construction disputes that cover those ranges of jurisdictions. I've been tasked, Matt, I think, to talk about due process. And I think in there, I've got quite clear views about guidance. To answer your question, Seoul Protocol, yes, it is on the table in things that I'm involved with. People are referring to it. They're referring broadly across the range, but there are so many common themes, I think, that one's not tracking them back now a year into where it comes from. Is that your experience, Colin? The people are talking across the spectrum.
Yes, obviously, I've used the Seoul Protocol for KCAB matters, but the Seoul Protocol has also been applied in other arbitrations. It's a very useful set of guidelines, and quite often the tribunal and the parties work out a form of virtual hearing protocol, taking from the best of the Seoul Protocol, the Chartered Institute of Arbitrator guidelines on how you use technology, how you deal with procedural issues during virtual hearings. And of course, the HAIC guidelines are also very important. So I think there is more of a trend to use a bespoke guidelines where both sets of counsel and law firms are sophisticated users of arbitration. So I think it depends on the quantum of the construction arbitration that's being looked at, and also the quality of the tribunal and counsel appearing in the arbitrations.
Yeah, I think that sounds right to me, and I myself have observed that arbitrators will often have their own kind of preferred protocols that they will recommend to the parties, and I dare say in many instances those will have at least been inspired to some extent by the Seoul Protocol and by other guidelines, as you mentioned. If anybody who is attending has other experience with other protocols that haven't been mentioned that they'd like to everyone to be aware of, please note them in the chat function. But perhaps in the interest of time, we can continue our discussion with the next topic, Marion. And here you'll be talking about practical challenges in ensuring procedural fairness. Particularly in the context of the sorts of issues that arise in a construction dispute where you've got people all over the place and in remote locations. So
yeah. Thanks for that introduction, Matt, because as everyone on this call knows, procedural fairness is absolutely fundamental. And we have a wealth of guidance available, whatever the dispute resolution method that we're using, whether it's ADR, whether it's adjudication, dispute boards, mediation, wealth of guidance. And I'm just going to suggest that we keep this very, very simple. And we remember that guidance is simply that, it's guidance. And that means that you as a dispute resolver can look at it, use it as a checklist, be prompted by it, but ultimately you have to make a decision that works for the dispute that you're looking at. You have to step away from that guidance, particularly as so much of it has been written and superseded because we are in a rolling situation. I've only got 3 points that I'd like to use to illustrate that. I want to start with remembering who it's really for, remembering what's technically possible, and then to deal very lightly with the gold standard of the common law system, or is it witnesses? Who is this really for? I fear that there's a risk that we think it becomes about us as the dispute resolvers and the lawyers, rather than focusing on the clients. And I think it comes about because we are all so amazed that we've managed to keep the show on the road, that we are facing the challenges of the technical system, that we let almost an air of self-congratulation. Well, there's a risk of doing it. You're all probably well aware of this and can avoid it. But we, in minor ways, exclude the client. Yes, we have to build trust and confidence, and yes, a degree of informality works. But I think we need to monitor that it doesn't go too far, that the use of first names and comments about the backdrop and where's the cat, perhaps we need to just think and remember that at the heart of this is a business in crisis that wants a degree of formality and to be heard. What's technically possible? Now, just have a look at where you currently are. And I suspect that many of you have a raft of screens and you've got your halo light now, you have your special mic, you're operating on 3, 4, 5 screens for any of these conversations. That isn't necessarily the experience that will be shared by everybody in the dispute resolution process that you're involved in. In the economic freefall that we're in, the luxury of bringing the engineer or the operating officer off-site to a meeting, to a hearing, is not necessarily going to be available, if it ever was. Clients, witnesses may be participating from their lunch break, from a canteen. You hear stories of the witness who, when he pops up on the screen, is plainly in the bathroom. And he's there, not out of any disrespect to the process or making some sort of oblique point. He's there because, one, it's quiet and the only place on site that will be quiet. And it's also the place where the best Wi-Fi is. He may be sounding like he's at the end of a wind tunnel, but that's the best that can be done. So before we become concerned about arrangements for electronic bundles and all of the wonderful things that we can do from Opus, I think we need to think about drilling down into the realities. How is this actually going to be run at a tiny, minute level? Check the basic arrangements. And that takes me on to the position of witnesses. And I think I've got 2 points to remember about that as we move, I hope, into a world where we can start to move around and to meet again. Everyone's acceptance of risk is different. And I think everyone has to be allowed to express that and to feel that they are protected, particularly a witness, because they don't have to be there usually. They don't want to be there. It's an uncomfortable process. So we need to think very, very, very carefully about simple things. How are you going to maintain social distancing? What are you going to do about masks? How are you going to deal with the taking of the oath? All of those things need to be thought through, and they're not necessarily covered in any protocol and may in fact be dictated on a step-by-step basis with a different system for each of the witnesses that comes in front of you. And the only other thing I would say about witnesses is that as we move into the potential use of hybrid procedures, when we have a witness coming in remotely and a suggestion that the dispute board, for example, will be dialing in from separate places, or that part of them will be in a room with one of them dialing in, I think it's important that counsel and the tribunal deciders have the same experience. If you accept, and we can talk about whether or not this is right, that witness evidence is the gold standard, I'm not convinced, but let's accept that as a proposition. Everyone must share the same experience of that witness so that you can make meaningful, relevant submissions, having seen the same evidence being given in the same way. So those are my thoughts, Matt. There's so much on due process that you could pick up, and I'm sure the panel will have lots of different ideas on that topic as well. So far, yes, it's provoked one question, which perhaps we can take at the end. I'll have a think about it.
Thank you, Marion. I think there's a lot there, and I think it's right to say that there is a tendency for us to think that the hearing is for the lawyers who are adept in the use of all of these tools. But taking the oath, I mean, there are complexities there that I think we don't often turn our minds to properly. Any comments from you, Alfred, or from Colin, on this question of how are we going to ensure procedural fairness in practice? I mean, one of the issues that has been touched upon at various points today is the question of participants in lots of different time zones. How are we managing that? Colin, in practice, when you've got, say, experts in Europe, witnesses who are now maybe on another project site in, say, Latin America, and maybe the hearing is or the arbitration is seated in let's say Singapore. How do you manage that in practice?
Now, that is a very contentious area because obviously counsel would like to have the hearing heard at a convenient time in their time zone. Usually it's not too much of a problem if you have a time difference of 8 hours. So let's say Singapore, London, because you can adjust for that, and each side can compromise. The London team can start slightly earlier. Singapore, Hong Kong, or Asian time can start later in the day. But the problem then arises when you start having counsel and tribunal and witnesses dispersed across the world. And when you start getting into multiple time zones, 3 or 4 time zones, and 15 hours apart, that is where the real issue comes into play. So one of the theories which I like to float is usually there has to be a more dominant time zone, and if everything being equal, you've got equal spread of counsel and witnesses across, let's say, 3 or 4 time zones, I think it would be fair to say that the time zone of the seat of the arbitration should take a bit more dominance, because people have agreed to arbitrate in that particular seat. So if one says, we've agreed that the seat of arbitration is London, obviously there has to be give and take. Everyone compromises, but I think it's important also to note that the people who are in London and have expected to deal with any disputes there, I think they would have to have a slight priority, because usually when you have transcripts coming back, you like to have your transcripts coming back before midnight, in whichever time zone that you're in. So somebody has to compromise. And I think, although everybody compromises, I think the seat of arbitration, I don't think you should sit past 10 p.m. Ideally. So, you know, having said that, I've set at horrendous times, ending in the early hours of the morning, because you know, if I'm in Asia and the time zone is New York or London, so I have to compromise. It's not a hard and fast rule. Obviously, you look at where the numbers of participants are, but all being equal, I think the dominance of the seat, the time zone of the seat, should take a little bit more precedence.
I think that's very sensible. I mean, obviously in construction disputes, we do have many cases in which all of the tribunal members happen to be based in one very great and grand city that we all know well and love, even though the arbitration might or might not be seated there. So the next time I'm in one of those situations, I will remember the dominance of the seat theory and quote you on it. Any other comments, Alfred? These situations for tips for practical.
Yeah, sure. Sometimes, yeah, yeah. I mean, sometimes, you know, like inequality, you know, does not have to be sort of substantive inequality, right? Sometimes perceived inequality can, you know, throw a lot of, you know, sort of difficulties for, you know, for participants in virtual hearings. I mean, you know, for instance, you know, like, you know, if we have a hearing in let's say that the hearing is happening in London, and you know, we have our witnesses, you know, one party have their witnesses and counsel, or some of their witnesses and counsel in London, but the other side have their counsel in Hong Kong, and some of their witnesses in Hong Kong. I mean, the fact that, you know, one side's counsel is, you know, is so close to the tribunal, you know, that you know, itself, you know, will be seen by the other side as, you know, having an advantage. So to deal with that, sometimes what will have to happen, unless the parties, you know, can agree that, or you know, unless there's been some other agreement between the parties, is, you know, like, even though the tribunal and counsel and the witnesses are in the same city, in you know, they still need to be put in separate rooms, so that, you know, if you're operating in the you know, in the arbitration center, in the International Arbitration Center in London, for instance, you know, the tribunal will have to be in his own room, his or her own room, and then, you know, counsel and witnesses will have to be, you know, even though they are also in London, will have to be sort of fed into the tribunal's hearing room through a video link. This is just to remove any perceived, you know, inequality, you know, when it comes to sort of appearing before the tribunal. So that is the sort of things that will make the, you know, the arrangement sometimes, you know, quite complicated and unwieldy. But it is necessary in order to, you know, to preserve the integrity of the process.
Yeah, I think that's sensible, and I've encountered that situation myself. We've seen similar problems in the past. You know, before this new age of virtual hearings, when we were dealing with case management conferences, and you would sometimes have counsel wondering whether they could, you know, be in the same conference room with an arbitrator joining, you know, a CMC. But this is obviously taking on a different dimension of gravity, obviously. Well, look, this is all very helpful and interesting. Colin, why don't we move to you now, and let's shift our focus from these challenges in ensuring procedural fairness and in making sure that the thing works, overcomes objections in a sense, to the issue of how can we utilize these skills? How can we present evidence effectively in construction, in virtual hearings, in construction disputes? I think there are a lot of challenges there, and I'm hoping that the panel will have lots of good ideas for that. So Colin, why don't you kick us off on that subject?
Sure. So I think the most important aspect of a virtual hearing is one needs to master the use of the e-bundle. All parties have access to the same electronic bundles on the same platform. And as highlighted by Alfred earlier, the use of sharing documents on screen allows the advocate and opposing counsel arbitrators to look at a certain document without having to leaf through the various hard copies in traditional in-person arbitrations. However, it can be quite difficult sometimes for the advocate or even the arbitrator when the arbitrator wishes to put a question together. It can be quite difficult to direct the operator from Hkiec or Opus or any other platform to perhaps zoom in and hone in on a specific section of a chart or a large document or schematic plan. So one does not have the advantage of having a laser pointer where you can direct participants to look at a certain part of a large screen, which you do in a physical arbitration in the hearing room. So it's quite imperative for lead counsel to be able to direct, to be able to take over the operation of loading the documents from the operator of the virtual platform. Then you can direct the factual or expert witness to look at a certain part of the document. It's much easier than telling the operator to say, operator, go a bit more left and a bit up and hone in there. That wastes a lot of time, and it often detracts from the tribunal's attention. The tribunal is just picking up very important points, and it wants to look at documents. And the witness is also getting edgy when you're lead counsel. You want to cross-examine and take advantage of the situation. So and it's also very important to be able to do this, because if you're lead counsel, you need to quickly respond to answers coming in from the witness, where the witness may try to evade answering the question, and you have to put the witness back into the corner by using those documents. So that's very important. And obviously, legal teams tend to be geographically dispersed. And even if everyone's in the same city, there may be a lockdown. And it's very important to be able to get the legal team to work together so that everyone can contribute and do their best. So that's where you need to have another private online platform, workspace or whatever, so that you can communicate. So the lead counsel can direct the second chair or juniors or solicitors to look at certain documents in their own respective core bundles, which will often be marked up with comments and counter arguments to what the other side has presented. Now, this advanced preparation might be wasted if the rest of the legal team cannot communicate with lead counsel and they are unable to interact. And obviously, in construction arbitrations, there are massive amounts of documents that one has to go through, and different members of the team are usually accorded with different responsibilities. So if one can enhance the efficiency of your own legal and expert team, you then are able to cross-examine very efficiently and smoothly, and not give the witness a chance, or expert witness a chance to slip away. And this eliminates the need to email documents to each other to say, oh, take a look at this document, perhaps we should use this document against the expert, etc. So organization using the e-bundle and using your own separate platform Also important to be able to quickly communicate with your own clients, particularly if something comes up in the cross-examination and you need to take an urgent instruction halfway through in the hearing. Another way one can work efficiently is if your lead counsel ensure that your team creates a lot of hyperlinks on your own private cross-examination bundles, because then you can ensure a very smooth, effective presentation online. And if your presentation is effective, it not only attracts and keeps, it holds the attention of the tribunal, but you also save valuable time on your own chess clock when you're doing a cross-examination. So the role of the second chair is very important, because the second chair will have to assist the lead counsel by going through the live note transcription and search through the same, and where there are inconsistencies in the evidence given by the expert or the factual witness, to quickly give the page and line reference to lead counsel to allow lead counsel to further attack the witness. One of the difficulties, obviously, is we tend to deal with very large documents in construction arbitrations. We have spreadsheets, schematics, charts, maps, drawings, photographs. So while it's easy to load the documents onto the platform, it is definitely very important to ensure that the resolution of the documents that you want to refer to is a very high resolution, because one of the most irritating things to a tribunal or arbitrators is to look at the document and they try to blow it up to 300%, and the resolution just fades and they can't really see what's happening on the Primavera schedule or the chart. So I think one of my personal suggestions is that construction counsel and arbitrators should try to use large monitors, a 60-inch screen, high resolution monitor or TV, so that the page which is being presented on your virtual platform, it just opens up very decently. It's easy for you to look at, basically. It's important to safeguard the integrity of the cross-examination process. You want to make sure that there is no secret witness coaching going on during the cross-examination, and that the witness is not looking at WhatsApps coming in or even on the screen. Obviously, it's important for counsel to be able to ensure that there's somebody in attendance in the room to check that the witness is not doing such. So I think a very good way to counter this is to ask to have a protocol where all witnesses should try to attend the nearest neutral office. It doesn't have to be an arbitration center, can be a neutral law firm, it can be an accountancy firm or any conference center. And if you have a venue where you have 360-degree cameras, that takes it up completely. And the techniques to present evidence is quite different, because when you're looking at a witness and you're cross-examining a witness, while you can look at the face and facial expressions of the witness carefully, lead counsel often you look at other physical attributes of the witness. You look at the hand and feet. Are they drumming? Is he drumming his feet? There's so many things to look at. And it's very important to be able to look at opposing counsel, because sometimes the other side's counsel gives the game away. They'll be grimacing, or they'll be putting their hands on their heads, whatever. These are the things that lead counsel miss in virtual arbitrations, and you cannot see what the arbitrators are doing because the screens are so small. When you're cross-examining, you want to know, is the arbitrator actually being attentive? Is he jotting something down? Is he looking at the witness with a smile or a scowl? So things like that are missing. So these are some of the things to look out for. So I'm going to sort of like end quite quickly, but I would like to say something about expert witnesses and how you deal with expert witnesses. It's more difficult now to do hot tubbing or expert witness conferencing virtually, because obviously counsel tends to present the best parts of their expert theory and attack the opposing experts, but they may strategically avoid focusing on specific areas of dissent between the experts. So tribunals tend to want to do hot tubbing and get them to sit together and try to ask them to give concurrent expert evidence. It's more difficult now because where they're no longer sitting next to each other, there's less of a chance of them to have a bit more respect, be a bit more respectful when they're sitting next to each other in front of the tribunal in the same witness box. So it's essential for the tribunal in virtual hearings to be able to control expert witness conferencing process even more tightly. So tribunals obviously have to be very careful at how they direct their neutral questions to the witnesses, but it's important to give them adequate time. It may not be equal time, but it's a fair time, adequate for both sides to answer, because some experts, one would notice, from certain jurisdictions, let's say London or New York, they are very good at dealing with virtual presentations because they've done so many, whereas those coming from smaller jurisdictions tend to be not so experienced in this, and they may not want to voice out and say as much as possible, and they may even be giving evidence through an interpreter. So it's important for the tribunal to keep a tight rein on that. In the interest of time, I think that's all I have to say. Thank you.
Thank you, Colin. I think those are all very interesting and valuable comments and perspectives. You know, there are so many challenges, the documents. One might have thought when we started this a year ago or some months ago that somehow this would be what enabled us to escape the tyranny of the bundles, the hard copies. But I don't think that's realistic in practice. I was particularly interested in one of your comments about the difficulties of really observing the tribunal's reactions in real time and knowing whether what you're doing is of assistance and whether they're looking at the right document and what are they doing. I think, at least in my experience, I don't think we've settled on solutions to these problems, though I think we're getting a little bit more adept at them. Perhaps just in the interest of time, unless Alfred or Marian have urgent interventions, maybe we could look at some of the questions. We've gotten a number of interesting questions from our audience. One, I suspect we've just dealt with. Colin has just talked about hot tubbing, David's question about that. And I think the verdict there is that can work, but one, it's perhaps even more important than it always is. We know the importance of tribunals preparation for an effective hot tubbing, but maybe that's even more important just in the management of the flow of discussion. Any other comments on hot tubbing?
Sorry, Marianne.
Can I just share with you this? And I'm hearing that there are more hung juries in jury trials. Why am I telling you that? It's harder to reach consensus in the current climate. And I take that into any proposal to have concurrent witness, expert evidence, which builds on consensus.
Yeah.
Sorry, Alfred, that's all.
No, thank you, Marian. I couldn't agree more. I mean, the dynamics in a hot tubbing exercise is different when it happens virtually than if it happens sort of physically with two experts sitting next to each other. But it it does work to a certain extent. We've had that done in a recent hearing that was relatively successfully. I think it involves the tribunal more, the tribunal asking sort of a very sort of keeping a tight rein on the hot topping process by sort of the tribunal driving most of the the questioning and getting sort of one expert to give an answer and then the other expert to give their answer. You have to have enough screens in the room because you have to have a screen that is for the expert who is in a different jurisdiction, and you have to have a screen for expert 1, a screen for expert 2, a screen for the tribunal, a screen for both sides counsel, a screen for the documents. So you do get the hearing room all plastered with screens, and then you get confused as to which screen to look at any particular point in time. So it does require some adjustment, but I've seen it work reasonably well.
Yeah, and I think one of the takeaways from this discussion is that the normal arrangements that might be perfectly suitable for an ordinary commercial dispute in a post-M&A case or something like that might not be adequate in a construction dispute where you require higher resolution screens. Otherwise, you imagine looking at Primavera files for a week on end. Not an easy thought. Bernard Meyer had an interesting question about how can the integrity of a witness testimony be guaranteed in a virtual hearing? And I think, Colin, you had made reference to the availability of sort of 360-degree cameras. This seems to be part of the solution. Perhaps confiscating devices might be another, maybe having somebody in the room, but are there any other suggestions from the group?
Just read the documents. That's what you have to do in any commercial or construction arbitration. The story, what happened, is largely in the documents.
One, I think it's obviously more difficult to deal with this when the witnesses are giving evidence from their own home. So that's why it's very important to have a protocol to get witnesses to go to the nearest neutral office or conference center, etc. I think so long as there's somebody neutral, somebody reliable, or somebody from the other side in the room to ensure that the witnesses are all using clean copies of witness statements or expert reports, etc. I think that would be the best solution because not everyone will have a 360-degree rotating camera, but you can easily put someone over to say, well, look, that's the rules of the game. We have to make sure that there's no coaching going on. So I think that would ensure the integrity of the arbitration. But I see a question on hybrid hearings. 2 questions. If I may quickly answer that, Matt.
Yeah, and I would just say I suspect that Dorothy might have raised that in response to our discussion about the difficulties when you've got, say, an arbitrator and a counsel or an expert, somebody in the same city, which is different from where others are located, and you need to segregate them effectively.
Yeah,
I might be misunderstanding Dorothy, but that was my assumption as to the timing. So I think that was the context.
I think it might have flowed from what I said about the lead counsel and the tribunal, or the lead presenters and whoever's deciding. Yeah, that's correct. Needs to see the same evidence.
Yeah.
And I'm not saying never, because I think in this field you should never say never. Although I have got one general principle that I will give you right at the end, which is an absolute. There are no exceptions. But in relation to this topic, I think just be very, very careful if it is hybrid. And if you are breaking up the experience between lead counsel and the tribunal, just think very carefully that one through. It's my take. Do you agree, Colin? Do you agree, Alfred, Matt?
Yeah, Colin, what were you want to say to that?
so I did 5 hearings, 5 hybrid hearings last year, both as lead counsel and tribunal. I think it works quite well. I think it depends on how you define hybrid hearing. Obviously, if all 3 members of the tribunal were sitting together, then okay, you might have an argument to say, well, it's unfair because lead counsel sitting in the same room with all 3 members of the tribunal might have an advantage. But I think quite often, and in the ones I did, I wasn't there, but I didn't see any disadvantage to do it virtually, and the other lead counsel was in the room with one of the arbitrators. Because quite often the arbitrators are themselves dispersed in 3 different jurisdictions or even 3 different rooms in the same city. I think I don't see any advantage or disadvantage for half a team or even one full team sitting, in Metro Chambers or HIC or Fleet Street. I think the perception, it's not, it comes, when you think about it, it seems unfair, but unless all 3 members of the tribunal are there, I think everything's being recorded on transcript. Everyone sees everything. The camera is there. And in fact, I would say that it can be more disadvantage for lead counsel to be in a big room because the technology may not work as efficiently when you're looking into a screen, basically. But I think one has to define hybrid and what you mean by hybrid. If it's hybrid where tribunal members are scattered around and counsel and experts are also scattered around, one side may have 3/4 of their team there. I don't think that would count as a unfair process.
Yeah, but it's certainly one that raises sensitivities, I think, and one would have to be consider the circumstances. Just looking at some of the other questions we've got, Bernard also asks whether there are recommendations for infrastructure providers. I've heard references today to Epic and to Opus. Any other suggestions?
I would say, contact your arbitration center, where you are. They are usually the people, with the best resource in lining you up with these service providers.
Yeah. I think we're already seeing more of these service providers launching as startups. And so it'll be, I think, a really interesting development to keep an eye on. If other people in the audience have recommendations, please add them in the chat function. I think we also got a question from Richard asking whether there were concerns about more challenges to tribunals concerning breaches of natural justice as a result of virtual hearings, maybe in circumstances, I guess, where a party felt that a physical in-person hearing was what they were entitled to. What do we think about that? Marion, did you have some comments on that? A bit of a sensitive issue, I think.
Well, I think firstly, I hope this isn't sensitive. I think data, we talk so frequently about the construction industry's response to alternative dispute resolution, and we make predictions about its behavior. And on almost every aspect, we have very limited data. And there's a huge piece of work to be done between those who provide it and those who use it for us to work out what the real on-the-ground position is. So that's my first plea. And my second plea is, if one can distinguish anything, I think there's a trend towards challenging enforcement generally, and people will use the arguments they've got. And in the circumstances in which we are operating at the moment, they will look very closely at the process, but they always have done, and they always will. So I'm not going to predict whether there's going to be an increase. What I do detect, though, is a huge desire on the part of those who provide these services, the dispute resolvers, to get it right. Witness the attendance and the signing up, and people sticking on this call.
Yeah.
15, a year into this pandemic, and people are still thinking, am I getting it right? How do I do it? What could be better? It's a good business to be in. We can pat ourselves on the back on that.
Yeah, and I think it may be too early to tell whether those challenges increase and where and whether they succeed. But that's certainly something that we'll all be watching carefully. Cian Merchandani had a question about efficiently managing the documents for cross-examine a witness. And I think we've all one of the issues that always occurs to us ordinarily, even when we were doing this all in person, was whether we want to have different types of bundles, cross-exam bundles, or in addition to whatever sort of e-bundles we might be using or hearing bundles we might have constructed. What is people's experience on that? Colin, you had some comments. Marion or Alfred, any other suggestions for documents?
What I think one technique that works is you send the documents in advance, the hard copies in advance, to your representative in the jurisdiction where the witness is, and you hand the hard copies in a sealed envelope when the hearing is starting, when that witness is about to be cross-examined, because usually the witness, when you load documents on screen, the witness might say, well, I'm not sure where the context of this particular page. I'd like to see what's on page 1, etc. Where did this document come from? So all of this time wasting can be dealt with if the documents are given in their whole and tabulated, flagged with sticky notes to say that's a document you're looking at on screen and that's a document it's from. But obviously you need to have support. It only works if you have somebody on site who is able to hold on to that sealed envelope and then pass it and open it up before the hearing. Wouldn't quite work if the witness is somewhere, I don't know, in the middle of a desert or something, or living somewhere. Yeah.
I mean, what you're describing, Colin, is not really a new challenge. I mean, we have been cross-examining witnesses who are maybe they've moved on to another project and are on site maybe during commissioning and they can't get away for the hearing. And we've had to think through how to do this, and oftentimes somebody's had to get on an airplane with a bundle of documents. But I think this is something we're thinking about more frequently now. Alfred or Marion, any suggestions?
I usually, first of all, cross-examination has to be far more prepared. You're going to have identified the list of documents. There's no winging it on the day and leaping around. But secondly, I quite like to have tech support split. So each side has someone nominated as tech support who will, when their team is cross-examining, be in charge of the presentation of the documents. So that in that way, you can maintain the integrity and the element of surprise. Although frankly, in cross-examination, is there ever a surprise? I suspect we can all predict the documents that would be put. And yes, they are put to the predicted effect.
Yeah, I mean, we don't always come close to Jerry Spence's standard of bring me the 29 documents that are going to win this case for me, and if it's 30, you're fired. But we try to get close to that as we can. I think just on that comment, Marion, there was a discussion earlier about what to do when witnesses are testifying from home. And one thing that I've seen, I think that your comment about the need for tech support applies there as well. We've had arrangements where we have said, okay, if something goes wrong, we will have tech support within 5 minutes of where you are. They'll be on standby. Hopefully they won't need to do anything, but heaven forbid there's an issue. That's how we will maintain the continuity of the proceedings. So this is all something that we need. Alfred, did you have any last comments on that?
Not really. The challenge that that just been talked about, is not just for virtual hearing, is for physical hearing as well. And you always have to have a clean set of documents prepared for the witness, clean set of bundles for the witness. But in a virtual hearing, you probably also need an electronic set so that it can be brought up on screen. Tech support is important, of course, because like you need someone who can navigate through that e-bundle very quickly. Otherwise, you're wasting a lot of time in the virtual hearing process. So
yeah, I mean, we've talked a lot, and I'm mindful of the time. We're already over time, but as long as we've got kind of a quorum of participants, maybe we can continue. I think we'll end soon. But we've talked about challenges of various types of construction evidence. One thing that we haven't, I think, talked about specifically is what do we do with physical evidence? Is that just when the case where you want the tribunal members to look at a particular fitting or maybe
yeah,
it's useful to have some sort of a mock-up where they can understand what was visible through a boroscope inspection or something like that. Is that just something we can't do right now through virtual hearings, or do you have any suggestions?
Well, I'll go first. Everyone these days, Matt, can do a video. Everyone can make a video. And that's what you get. You get, these TikTok videos. Sometimes I think there's music in the background or someone is listening to music while they're filming it, and they'll take you around the model. You can then, in the hearing, say, we've watched that was very useful. Could you now, in the hearing, actually let's go back to the model and can we look at this bit? So you can do it. And we're going to, I've heard tell that they're talking about using holograms for witnesses. Do you remember Star Trek Beam Me Up, Scotty? Well, that's, I think, the next stage that we're coming to. We'll look back on all of these problems as being nothing.
No, I agree. I think the carefully put together videos are very important because it explains the position to the tribunal. But where you need to look at models, that's where hybrid arbitration can be quite useful too. So I had a case where I was a chair, but I wasn't able to get to that jurisdiction, and neither was the other arbitrator, but we had one arbitrator on site, and the arbitrator was able to direct the cameras to go in and take shots, basically. So that works as well.
Yeah, well, another, if we cannot get away from, presenting physical evidence, if sort of video or computer modeling doesn't work, and then we have to resort to a physical model or physical sample, the challenge for virtual hearings is that you have to have multiple sets. If you have, tribunal in London, witnesses in Hong Kong, and expert in, in Singapore or whatever, in order for everyone to be able to feel that piece of physical evidence and to look at it, properly, then you have to have multiple sets, and then you have to be prepared to ship those multiple sets across different jurisdictions very quickly, which often is not easy. So you really need it comes down to, proper planning. You really need to plan ahead as to, what physical evidence you need. And also, we talked about large plans, in construction projects, always have large plans, large drawings, right? So, if you have to have a large drawing, printed out, in different jurisdictions, you've got to have access to that facility. And if you don't have, if one particular location doesn't have, the ability to print out, A0 size drawings, and then you have to resort to the screen version of it, then you better have, as Colin said, you better have a good, detailed, high resolution version of that available. Otherwise, you'll be putting that person, who does not have that printout facility, in a prejudiced position.
Yeah. Thank you. I think that's all very interesting. And I wanted to have made sure that we had adequate discussion in this, well, at least sort of reasonable amount of discussion on dealing with construction evidence, because I think it is something that's useful for us. I think we probably should wrap it up, but maybe we could close with Jeremy's question, in which he's asked us to engage in a little bit of crystal ball gazing. Jeremy has suggested that for shorter hearings, virtual and hybrid hearings are probably here to stay, clearly. But for hearings of 3 days or more, what's the panel's best guess about how many will be entirely virtual and how many in person when the world has returned to something like normal? What are your thoughts on that?
I'll go first while everyone's thinking. I think that the pressure of the economic downturn will be such that parties would insist upon staying virtual. It is so much cheaper. And I will share with you my last piece of advice, which is always dress properly from head to toe, not just from head to waist, because you never know when you have to stand up. That's all I've got to say.
Right.
I have the same comment. Sorry, Colin, you go first.
No, you go first.
You want to preserve, the senior counsel always want to preserve the last word, do they? Well, I share the same sentiment as Marian. Like virtual hearings are here to stay. It is, much cheaper. Instead of flying people around, particularly, I don't want to make prejudicial comments about people flying business class, and things like that. But but it is very expensive. It is very expensive. Carbon footprint comes into play in that. Some organizations have a policy against flying business class because it involved a much larger carbon footprints than flying economy. Putting up people in hotels, food and stuff like that, and also downtime, that people have to spend, traveling, from one place to the other, adjusting to time differences. All of that adds up, and it will make, and it does make physical hearing quite expensive.
Colin?
Right.
What does your crystal ball say?
My view is I agree with everything that Alfred has said about being able to save costs by doing virtual hearings. But my view is virtual hearings for smaller quantum disputes will be prevalent in the post-COVID era. But for large value construction disputes, I expect a full reversion to in-person hearings. So if you've got a case that's worth 200 million US upwards, basically, I think both sides and counsel would prefer to have in-person hearings, because you are able to present your case more effectively in an in-person hearing. So it depends. Small cases, yes, definitely. I think we will see a prevalence of virtual hearings, but not for the large quantum cases.
Yeah, I think that's very interesting. I have kind of a similar view. Frankly, it may be that in the future we will take a virtual hearing as kind of the starting point, and then we will ask a separate question about whether an in-person hearing is justified in the circumstance of that case. And we may also break things up, and we might have virtual and in-person physical elements. That seems possible as well. All of which can be dealt with, of course, within the framework of arbitration. Look, it's been a very interesting discussion, and I really appreciate everybody who has stayed with us to the bitter end. Let me just close by thanking our speakers. I also want to thank Jack Lee for attending and giving us his welcome remarks, and for the organizational wizardry of Rhonda London from the IPBA Secretariat, whose assistance is invaluable, as anybody who's tried to do one of these events will know. As I mentioned, this is the second in a series of these webinars. The next event is not yet, the date is not yet fixed. We expect it may be toward the end of March. So please watch your inboxes for news on that. I suspect we'll be talking about renewable energy projects. And I think we have a discussion with Energy and Natural Resources Committee. So when the agenda for that event is fixed, we will be informing everybody. And please also reach out to us if you would like to participate as a speaker in a future event. That's really, as I mentioned before, one of the key objectives here is to encourage that kind of participation. And so with that, I will, and also with thanking all of our attendees, I will close this webinar.
Thank you.
Good
Thank
evening.
you. Good evening. Good evening.
Bye.